Hello, and welcome to episode 5 of our financial planning education series. During this episode, we will review the basics of estate planning documents, as well as some easy pitfalls to avoid, and then we'll dive into some more complex fact patterns to illustrate some situations we've worked through over the years. First, let's review the actual estate planning documents and how and when they operate. As you can see here, general powers of attorney, healthcare powers of attorney, and living wills all operate during your lifetime if you're unable to make decisions for yourself. You can name an agent to make financial and healthcare decisions for you, and you can execute a living will to document your end of life wishes. After your passing, your last will and testament takes effect and ensures that your assets pass according to your wishes to the people you name and in the amounts you specify. Your will also names an executor to make sure your wishes are carried out. Now, to turn our attention to trusts, there are many different kinds of trusts, and we absolutely won't cover them all during this episode. Trusts can operate during your lifetime, after your passing, and many actually exist both during your lifetime and then remain intact past your death. Trusts can achieve many different purposes, including providing tax benefits and protecting assets. Before we delve into the complexity of trusts and other entities, let's take a look at some estate planning pitfalls to avoid. Here's a sentence I've heard more times than I can count. I'm young and single, I don't have much money, so I don't need any estate planning documents. And to that I say, what if you become incapacitated? Who will make medical and financial decisions for you? I've actually seen the unfortunate situation where someone has had to apply to a court to become a medical guardian, all because the incapacitated person didn't sign a power of attorney when she had the ability to do so. Another time that executing documents is essential is if you have young children. You want to execute a will that nominates a guardian for your children. Otherwise, if you and your spouse were to pass away, the court system would get to choose who would act as guardian of your children. And finally, the case of a single person dying intestate, which means you pass away without a will. Every state has their own priority list of who inherits from someone who dies without a will, typically a spouse and children, and then more distant relatives down the line. For someone who's single with no close family members who dies intestate, their nearest relative will inherit. So you could end up with a case where a long-lost cousin inherits your fortune when you could have easily executed a will directing it to maybe a close friend or a charity of your choosing. Here's another pitfall based on something we've visited a few times in our episodes. Take a look at this net worth statement again. Different types of accounts pass in different ways. An account in joint name, such as shown here in green, will pass to the surviving joint owner regardless of what your will says. This is typically the case when a married couple has a joint account. Now, retirement accounts, shown here in blue, pass by beneficiary designation, again, regardless of what the will states. This is also true of annuities and life insurance policies. And speaking of account titling, I've actually seen a case where someone went to the expense of executing a revocable trust, but didn't actually have any significant assets that were taxable and could go into the trust. Instead, their wealth was tied up in retirement accounts, which, as we've said, operate on beneficiary designations. So they were just left with an empty trust. I've also had experiences where people went to the trouble of executing a revocable trust, actually had taxable assets that could fund the trusts, but didn't remember to retitle their accounts to actually fund the trusts. To illustrate the importance of updating beneficiary designations, let's look at this chart. A woman executed a will to leave assets to 2 of her 3 children. but then she neglected to change her retirement account beneficiary designation, which still included the disinherited child. So here the intention was to split her total estate of 9 million between two of her children, and they would each equally get 4.5 million. But because she never adjusted the beneficiary designation on that retirement account worth 6 million, now children A and B received 1 million less than intended, and the supposedly disinherited child actually received $2 million instead of $0. For all of these reasons we've just described, we at Wescott conduct a thorough review of your estate documents, as well as your account titling and beneficiary designations. We work to ensure that your accounts reflect the estate scheme that you have planned. We also work with you to update any designations for accounts we don't manage, including employer-sponsored retirement plans, annuities, and life insurance, to make sure they match your intentions as well. Now, onto some more complex estate planning matters. I think that the best way to illustrate these are through some case studies. So in our first case study, we find that a married couple have both passed away, leaving assets in trust for their two teenage children. They had named two personal co-trustees to manage their trusts. We had the husband Joe's sister Patty, and we had Joe's best friend Bill. Bill was interested in some more complex investments, so he took a portion of the trust assets and put them in limited partnerships and some hard assets like silver and gold bars. Aunt Patty began to feel very uncomfortable with these investments since she considered them unsuitable for a trust that was being spent down to cover the kids' expenses. Aunt Patty also began to feel the strain of the relationship she had with her niece and nephew because they were constantly asking for money from the trust to buy fancy cars and take friends on expensive trips. So you'll see the two major issues we have here are possible investment mismanagement by one trustee and another trustee suffering from a strained relationship with her niece and nephew. Now, in this particular case, the solution was to utilize Wescott's trust services. It doesn't always happen, but in this case, Bill actually agreed to resign as trustee and allow Wescott Trust Services to step in alongside Aunt Patty. Wescott was able to more appropriately manage the funds that weren't tied up in Bill's investments and then slowly work through the issues of divesting away from the limited partnerships and hard assets. Just as importantly, Wescott is able to act as an objective third party regarding trust disbursements. So now the niece and nephew come to Wescott and we filter the requests. This has allowed Aunt Patty to resume her relationship as the fun and supportive aunt while making sure that all requests are still thoroughly vetted and approved before any money is distributed. Our second case study concerns Debbie, who plans to sell her professional service business for several $1 million. She has 3 adult children who are all married with children of their own. Debbie has had some disagreements with one son-in-law who has some interesting opinions on how Debbie should invest her money. And Debbie's also concerned that one of her sons may end up divorcing his wife. Debbie also owns an expensive shore house that all of her family comes and spends time in. And she has an old irrevocable life insurance trust called an ILET that she no longer needs. She wants to cash out the policies and invest the money in her personal account. So the major issues we spot here are Debbie selling her business. She's concerned about keeping all of her assets, including her shore house, in her family, and she wants to unwind her ILET. So first, regarding the ILET. Now, the purpose of this type of trust was to own an insurance policy on Debbie's life that would provide liquidity at her passing, but would not be included in her estate for tax purposes. So when Debbie executed this ILET, in order to remove it from her estate, she gave up control and ownership. At this time, she no longer has a need for life insurance, but it's not just as easy as taking the cash values and investing them in her own account, because, as we said, she no longer actually owns this policy. She could possibly surrender the policy and have the cash distributed to the beneficiaries that are named in the trust, or she may need to have the beneficiaries consent to terminating the trust. But she can't just unilaterally decide to take the money for herself. Now, for selling the business, Debbie can consider an installment sale. The new buyer would make payments over time, which would spread the income from the sale over the life of the installment note. This would prevent a large short-term spike in income, and it might even potentially allow the income that is realized to be taxed at lower rates. To address Debbie's concern about leaving assets outright to her children, we suggest the use of bloodline trusts. If Debbie leaves assets outright, potentially her son-in-law could get his hands on her daughter's inheritance, money could get tied up in the son's divorce, and ultimately the assets might not reach Debbie's grandchildren. Instead, by using a bloodline trust, Debbie can provide for her children during their lifetimes, protect the assets from in-laws, divorces, creditors, and then still direct that the remainder goes in trust for her grandchildren. Finally, Debbie can consider putting her shore house into a family LLC. This would accomplish her goal of keeping the house in the family and protecting it from anyone's creditors. When doing this, important considerations include creating an endowment fund that would cover annual maintenance expenses and larger capital improvements, and putting in place a mechanism for governing things like approving when construction or remodeling might take place, and even an agreed upon calendar for which weeks certain families would occupy the house each year. So a lot to think about. And finally, we have our third case study. Jim is a retired entrepreneur with a net worth of about $25 million. He was in on the ground floor of a startup, and as a result, he now has a very large amount of company stock with very low basis. He also has a personal residence that he plans to leave to his only child to enjoy for many years to come. Jim has a close relationship with several nieces and nephews. He would like to provide for them in some way, but he also wants to incentivize them to work hard. Jim is also on the board of a charity and would like to make a large gift to the charity. And just like most of us, Jim hates paying taxes. So the issues that we obviously see here are that Jim would like to reduce the value of his estate for estate tax purposes. He does not want to incur large capital gains when he sells his low basis stock. He also has charitable intentions and wants to incentivize his nieces and nephews. So one way to reduce the value of his estate would be for Jim to transfer his house into a qualified personal residence trust called a CUPER. This is an irrevocable grantor trust that allows you to take advantage of the gift tax exemption by putting the personal residence into a trust. It removes the residence from Jim's estate, including any future appreciated value. During the term of the CUPER, the grantor continues to live in the residence without any changes. Now, if Jim didn't outlive the specified term of the CUPER, the entire value of the house would actually revert back to his estate, so there would be no benefit. But if he does outlive the term of the trust, once the term expires, Jim can still occupy the residence, but he gives up ownership to his beneficiary, which in this case is his daughter. He then has to pay fair market value rent to stay in the home. And while that can be viewed as a negative for some, Jim is actually happy about it because it allows him to further reduce his estate because he's spending more on rent without gift tax implications. Obviously, there are some drawbacks to using this technique. His daughter would receive a carryover basis in the house instead of a step-up in basis. So if she were to sell it, she could incur a very high tax bill. And also another drawback is that selling a house can become complicated because of the various trust ownership. So CUPERs should be considered very carefully. They're not appropriate for everyone, especially in our current tax environment where the estate tax exemption is much higher. But in certain cases, they can be very useful. To address Jim's other issues, one way to achieve both his charitable goals and his interest in divesting his concentrated stock is to create a charitable remainder unit trust, or a CRUT. So Jim can transfer a chosen amount of the stock to a CRUT and name his favorite charity as the ultimate beneficiary. Once the stock is contributed to the CRUT, it can be sold free of capital gains taxes, so Jim can invest in a more diversified manner. The trust can then pay Jim an income stream for a certain number of years, and at the end of the period, the remaining assets in the trust will pass to the charity. And finally, for Jim to incentivize his nieces and nephews, he can put money in trust with certain restrictions. He could specify that the trust would reimburse them for college expenses if they maintained a certain GPA. For example, he would pay 100% if they maintained a 4.0 GPA, 80% if they maintained a 3.0 GPA, and so on. Or alternately, Jim could opt to provide a sum of money to them upon graduating from a university with a bachelor's or a master's degree, whichever he chose. So he could achieve his goal of providing them with funds, but also still encouraging them to pursue their education. So as you can see, in addition to the basics of estate plans, there are many complex techniques that can be applied, and we've only just scratched the surface. Not all techniques are appropriate for everyone, but when they are appropriate, they can help to greatly reduce taxes and protect assets for future generations. We at Wescott review your estate plan to ensure that you are maximizing your resources to leave an optimal legacy. Thanks for listening, and I'll look forward to having you join us for our next episode.